Okay, so we should be broadcasting now. Let's see. Great. I see that some of the attendees are popping in. Good afternoon, everyone. Thanks for joining us here. Hi, everyone. Good afternoon. Thanks for joining us today. We'll just give it a few minutes for everybody to connect. Looks like all of the attendees are popping in. So we've got Tanya, who's back in the office today, first day.
Happy about it. Hi, everyone.
Social distancing, right? Great. Hi, everyone. Thanks for joining. We'll get started in just a minute or two. And we have Vivian in the comfort of her own home. Vivian, thanks for joining us.
A pleasure.
So I'm not in Miami today. Is it sunny today, Miami, Fort Lauderdale, or has the rain come in as well?
No, it hasn't been great.
Not yet, but there's still time.
There's still time for it to rain. Shoot. Hi, everyone. Thanks for joining us. Okay.
This has been a mission.
Wonderful. Glenn, so we're broadcasting now. All of our attendees are joining us.
Okay.
We're going to give it a few more minutes.
Great. Sorry to be so delayed. Just tech troubles. I hope this is a stable Wi-Fi now.
Perfect. Yes, you sound great, Glenn. You sound better. So thank you.
All right. Good. Good. So how many people? Hey, Beverly. She's muted.
I'm here. How are you?
How are you, Beverly? Beverly, I'm really chuffed to be here today.
Oh, I'm glad you're here too.
But that was,
welcome.
That was for you, you know.
Well, I'm glad you could join.
Use all my favorite British slang on Beverly. So yes, I'm chuffed to be here.
Well, good. All right. I'm going to mute myself again now, though.
Okay.
Wonderful.
Okay. So, thanks, guys.
Everyone, that voice in the background was Beverly, who's the executive director of FPA Miami. So thank you, Beverly, for helping them put the event together. Okay, great. Well, it looks like we've got a bunch of attendees who have already joined us, and we're ready to go. So, Glenn, if you wouldn't mind kicking us off, that would be fantastic. Thank you.
I would be happy to. Welcome everybody. I've no idea how many people are here. Can you tell me, Cammy?
We've got about 20 so far.
Really? All right, we got a great group. So this is actually workshop number 2 in a series about going independent. And I was asked to participate here because I did this in my firm 5 years ago. So and the one that's already occurred, a lot of issues were talked about, like what's your model? Are you going to be hybrid? Are you going to be pure RIA, independent broker dealer, whatever. So this one is for those who want to go RIA. That is what we're going to spend all our time on today. And we've got some experts with us, local experts who can provide expertise. The issue here is compliance. I'm going to tell you, we did it 5 years ago. It's been terrific. I wouldn't undo a thing. And the whole reason for us was marketing. You can't market with a broker dealer. I mean, come on, how do you get an interview? Well, sure, I'll be interviewed. Give me the list of questions. Let me submit my answers to the broker dealer and I'll be back to you in a month. Yeah, that doesn't work. So we knew if we're starting out, we need to be able to market freely. So that was the primary impetus. And then, but of course, you pay a haircut to your broker dealer, but with that haircut comes all the compliance and the tech stack. So this now becomes your own responsibility. And that's what Cammy and Tanya and Vivian are going to get into today. So with that, Cammy, turn it over to you to make further introductions.
Wonderful, Glenn. Thank you so much. So I'm Cammy Smith, and I'll be moderating today's session, talking about the road to independence, particularly from the compliance and legal standpoint. And I just wanted to say thank you on behalf of our other panelists here to the FPA of Miami for allowing us to host these sessions. As Glenn alluded to, we're doing a series of some practice management sessions on this topic, particularly about what's the best business model for myself, my compliance, my practice, and how might I go about doing that. And with the FPA, really our goal is to provide unbiased education, right? So this is an opportunity to share ideas, to have fellowship, to ask questions, and that's really the goal for us. Tanya, Vivian, and I are all three independent, so we're attorneys and consultants, not tied to one particular company or product. So really our job is to help advisors so that they can help their clients. So thank you for having us and thank you for joining us today. Just a couple of housekeeping issues before we get started. One is that we will be giving CFP CE. So you can go into your account and register for 1 credit. You should be able to find the session as the emails told you about. Secondly, if you'd like to see our previous presentation from the previous session, that can be on the FPA of Miami website as well. So go ahead and look at that. That will really talk kind of broadly about the industry. Today, we're focusing on a specific component. The third thing is we're going to go through, we have some kind of questions for about 20 minutes or so that will kick us off. And then we'll open it up for just live Q&A and some polls and some fun things. So feel free to use the Q&A function in the webinar to ask questions and ask them as we go along as well. We'll try to take those as we go. So again, you can use the chat or the Q&A function is fantastic. We'll try to peel all those questions off, and we really want this to be an interactive session, an interactive dialogue, and really our goal is to help provide education and discuss pros and cons and some different things all for you guys. So thanks so much. So again, I'm Cammy Smith. I'm the owner of Revive Consulting. And essentially what I do is help advisors and advisory teams prepare for succession, grow, and figure out what business model makes most sense for them. So most of what I do is help kind of educate and form business strategy around going independent or figuring out a lateral move if they're not in the right business model or context. And so again, my goal is to help advisors. I was an advisor for 8 years myself. I was in kind of a I'll call it a quasi-independent environment. And before business school and I got my MBA, I was really, curious about how to provide the best client experience and realized that I was kind of blocked, as Glenn alluded to doing that. So really that's my motivation for helping advisors these days is to figure out how they live a better life, how do they have a better practice in this day with technology and different compliance conditions, and then how to do that to provide the best client experience in an ethical way for their clients. So thanks for having me. I'll turn it over to Tanya to introduce herself. Thanks for joining us, Tanya.
Of course, thanks for having me and welcome to everyone. My name is Tanya Lambrex. I'm an attorney with Bressler, Amory, and Ross. We have 7 offices nationwide, but 1 in Miami, 1 in Fort Lauderdale. I am located in the Fort Lauderdale office. Today is my first day back in my office, which I am very much enjoying. I am located in the practice area of what we call financial institutions law. So we basically handle all sorts of issues for any kind of financial institution, from banks to wirehouses to one-man RIAs. We see it all. We have a broad range of clients in those areas, and we really deal with all kinds of issues in that industry. Our firm is pretty well known for our financial institutions practice. Most of our attorneys here work in that practice group, although we are full service nationwide. And we have a lot of different practitioners that work in a lot of different areas in that practice area. So if a financial institution has a question, we have the answer somewhere in the firm. So thanks for having me.
Awesome, thanks, Tanya. Vivian, please go ahead and introduce yourself as well.
Thank you. It's a pleasure to be part of this webinar. I am a former regulator. I worked for the SEC in Miami. I was a branch chief for almost 10 years. And before that, I have worked for NASD in New York and Colorado, which is now FINRA. And in my experience as a regulator, I had the opportunity to audit many different types of firms and business models. So I was able to see what worked, what didn't work. And then when I went into private practice, I worked for an insurance company in New York that had an affiliated broker-dealer advisor, fund, and an annuity company, and also work for different banks, 2 international banks, European banks, that and the business was primarily with international clients in Latin America. Through that experience, I was a client of some of the top consulting firms in the country and had the experience of what works and what doesn't work. So as a consumer, I founded V&B Consulting Group in 2012, and my goal was to, as a boutique consulting firm, to be able to deliver at the level of a top consulting firm, but with personalized service and without the overhead that comes with the larger firms. What I find most gratifying of my practice has been working with breakaways. And to me, it's the conversation of having coffee or meeting them for, I'm thinking about this, do I do this? And the hesitation, and then taking the plunge and walking through the process, and then being able to go back a year, 2 years, 3 years later, seeing their business flourish. And like Glenn said, I have yet to find one that tells me I regret it, I want to go back to the corporate world. It's not an easy decision, and it's not for everyone, but for those that did it, there's no going back. And I think I speak for Glenn for that, right? So
Absolutely.
I hope to share in this discussion some of the things that I have seen that work and don't work, and we're open for questions.
Good.
Wonderful. Well, thank you so much to both Tanya and Vivian, and also to Glenn for today. So we'll go ahead and get started now. As you can see, we come with kind of different aspects or different disciplines, and often we would help advisors together in a team, Tanya, Vivian, and I think you'll see why in the different areas of our practices and how we help advisors. But that's our goal for today as well, is just to let you know that you don't have to go it alone, that there's people and resources and experts out here who do this every day, all day long, helping advisors go independent and find the right environments for them, and to do it, the right way up front. So we're here to take care of you. So again, just to get started on what we're going to be talking about, I'm just sharing a quick couple slides with you for today. So again, there's about 330 or so thousand financial advisors in the US, and about 86,000 of them are CFP professionals, the ones near and dear to my heart. So that for context, 9% of advisors went independent in both 2018 and 2019. So it's like 27,000 advisors who are doing this. So just putting in mind the kind of the context of we've heard a lot about why advisors are breaking away, why they're going independent. We'll get into some of the compliance and legal issues today. Last session, we really talked about the ecosystem on kind of a spectrum of most independents to least independents, and the different channels for financial advisors in the United States. And today, so if you want to learn more about that, go ahead and listen to our previous webinar on the website. There's also some slides. Today, we're going to be specifically talking about going independent, launching your own RIA, and what that means also between a pure RIA or considerations if you want to go with a hybrid affiliation. I also just want to note here that in this world of independence now, there's even more business models out there with RIA service providers and platform dependent advisors. We're not going to talk about them much today, but I do want to just point out that even in the independent world now, in the RIA world now, there's a different way to get the services you need from your back office partners in a different way. Really what I help advisors answer is, what do I need in a back office partner or partners, and how do I want to pay for that? And that can really kind of impact their model. So to go ahead and get started, I wanted to ask kind of everybody here, Vivian and Tanya on the committee, that often what I hear about from advisors and from clients before they start is that advisors think going independent is the best option for them. They think it's the best for their clients to be, working with them in a true fiduciary capacity. But they really are hesitant to go about it because they think it's too hard, or they don't want to start. So could you guys just let us know what resources are out there to help advisors launch and go independent? And Vivian, I'll turn it over to you first.
Okay, great. So like Glenn mentioned, you're paying for compliance and marketing and systems and technology. It's coming out of, in your present position, it's coming out of your payout, or it's coming out of your bonus, but you're paying for it. So when you go into the independent route, then you're going to outsource your compliance program. And the biggest, I've heard of a survey, and I wasn't able to find it for this presentation, but the biggest fear is compliance and that's the biggest hesitation. And what's key is to find the right partner that you're going to feel comfortable with, and that you're going to feel that you'll be able to grow with them and grow your business. So part of what we're going to talk about today, and I also wrote out some questions that you could ask your compliance provider, and we can distribute them afterwards. So the key thing is to understand what services are out there and what's being delivered.
Yeah, so I think what a lot of people thinking about going RIA are concerned about, and like Vivian said, is the compliance aspect, and for good reason. I mean, the regulators have the ability to shut you down completely and never look back if you don't take your compliance very, very seriously. And so a lot of advisors, are in the business of advising their clients. They don't want to deal with it. They turn a blind eye to potential issues they see in their compliance program. They don't hire the right people, or they don't even supervise those people that they do hire. And so you really need a compliance consultant and trusted partners that can help you and walk you through all the steps and ensure that you're keeping up with everything that changes in the regulations from time to time. I know some of you out there that have practiced for 30 years. I mean, this is a whole new ball game, and all the business is run completely different than it did 30 years ago. And those are important things to consider. So, from a legal standpoint, when you're going independent, you got to really look at where you're coming from. You can't just decide tomorrow to go independent. There's a lot of legal risk associated with disassociating from your current firm. So one of the things that the three of us who often work together with advisors looking to move to a different platform or a different business model, one of the things you have to look at is your current agreements with your firm. And those agreements, there's a broad range of agreements that a potential advisor could have. They differ from firm to firm, of course. They differ from when that advisor entered into the agreement. So if an advisor entered into an agreement 5 years ago, that agreement's going to look way different than an agreement from 20 years ago, and probably is going to be less lenient. So those are all really important aspects of the financial advisor moving from some sort of other business model to independent. There's oftentimes non-compete clauses in those agreements. There's rules on solicitation of clients, or even solicitation of other employees. So if you want to, for instance, bring another advisor with you, make a team, or if you want to even take your assistant from your current firm, a lot of employment agreements will have rules on that, and some don't. So I can also tell you that some firms are more harsh than other firms. So some firms will actually litigate employment issues from an advisor disassociating. Some firms will not. So those are all the kinds of things that we will talk about on the legal side if a advisor wants to go independent. And those conversations, it's important to have those conversations before making that decision. You want to know what your employment contract says, what your risks are, and from leaving that whatever firm you're at, and whether there's things you can and cannot do once you become independent. And you should know what those things are before you make that decision in the long run.
Awesome. Thank you so much. So we've had a couple of questions come in as well. Those are really great points. So one is we have from Omar saying hi to Glenn. So also, hi, Omar. Welcome to the session. Thanks for having you. Glenn wrote back privately. One of the questions that came in is how hard was it to integrate with a custodian? And I think what we heard from Vivian and Tanya, so obviously Vivian really helps on both the front side preparing to go independent and to make sure that all the compliance agreements and that matches with your strategy and with the custodian that you're going to, as well as on the back side, helping and put a compliance program into place. And so I think also when I talk with advisors, they're so used to paying for it from their broker dealer or their wirehouse that they don't even exist, that there's compliance experts out there like Vivian who have worked for the regulatory bodies who now do this for a living in a different way. They just pay for it in a different way. And as Tanya mentioned, one of the things that we want to do up front is make sure that we know where we are today from a legal standpoint, because that will drive the strategy of how an advisor actually goes independent, considering all these things, and to do it in a way that's professional, that's legal, and that has the best success for clients and advisors. And so when we do that, what we'll do, and part of my job up front is to really help advisors understand and form a business plan. So rather than just saying, yep, I'm going to go independent and launch IRA, we really start at the beginning to say, what really is my goal? What am I trying to do with my business, with my clients? And we form a well-rounded plan in the beginning. And part of that is to look as well into what assets you have, what's your investment management philosophy, how you price, because again, that will also then dictate what needs to go on the compliance strategy. One of the things that we also do is dig in, both Vivian and I will dig into clients' accounts and the assets that advisors use. And so we'll figure out, based upon what those investment management philosophies are, which custodian might be best for you. And then we make introductions and help that go through. And then again, tailor the compliance program to fit with that. So in terms of custodians, the big three out there obviously are TD, Schwab, Fidelity, and then, TD and Schwab may be having an agreement if that goes through. They have expertise in various areas. There's also a second layer of custodians that are a little bit smaller, but they're very, very good these days, and they've got great technology integrations. And so we find that the transition from moving from any platform into one of those custodians is pretty seamless if you do it right up front. So I'm just going to say that we answered that question. Excellent. So Vivian and Tanya, sometimes advisors say, great, I want to go independent, and they don't know where to start or how long it takes. So in your advice, when you're thinking about this preparation and forming this launch process, how far in advance would you suggest that advisors start, forming a business plan and looking at their compliance goals?
So it's a very important decision, probably the most important decision of your career. So the more time you give yourself, the better. So 6-9 months out is ideal, and working with someone like Cammy, that's going to help you really focus and prepare. There's a lot of training, there's a lot of marketing, there's a lot of things that go into the process. Now, I've had situations where we've done it in 3 months, because I've had a couple of advisors that worked with a firm that said, we're shutting down this part of your business, which represents half of the advisor's book that had worked on for the last 30 years. So the option was stay at the firm with half your business and half your income, or go independent on a very compressed time frame. So for the consultant, it's manageable. For the advisor, it's a very stressful way to do it in a compressed manner, but it can be done.
Excellent. And I know, Vivian, in previous conversations and working together, again, we would suggest the 6 to 9 months to allow for that proper preparation. Right. But you said in the past, really, 90 days to get the entity set up, et cetera, is a great time frame from the RA standpoint.
Can be done, yes.
Perfect. Tanya, what do you think?
Yeah, well, I would also point out, it kind of depends on what you're doing. If you're a one-man show disassociating from a firm, that's going to be a different scenario than you taking an entire group and forming a new RIA with that group. So there's a lot that might go into that process from a legal standpoint. So not only are we looking at all the agreements of everyone trying to move from their current firm, but you're also looking at getting new employment agreements done for everyone that's going to be joining you. You need vendor agreements reviewed. You need to create that corporate entity. A lot of times what we'll do is we'll review client disclosures, client materials that clients see, compliance manuals, things that the consultants might need like a legal perspective from or a regulatory perspective from. And we also like to highlight hot topics for new advisors. So the SEC is constantly putting out more information of what they're focused on right now. So if they come knocking tomorrow, we're prepared for at least what they've told us they're going to focus on. So that stuff takes time, and it takes time, especially if you're moving with a large group or with multiple advisors, or even joining advisors from different firms. We see that all the time as well.
Excellent. Awesome. And I think exactly, we're going to, we're talking about preparation and process and having the team to walk you through this. And we focus on our various areas of expertise, again, to make sure everything's coordinated. So in addition to the regulatory documents and the compliance programs that an advisor would need to put in place, in addition to the employment contracts, we also have to establish what type of entity do you want to open, so we'll have to coordinate with Tanya or a different attorney. We'll have to, contact either an accountant or a tax attorney to make sure that everything flows with everything coordinated together. So excellent. I think another important thing to bring up is allowing, 6 to 9 months as well. If you focus on the business strategy, then also we can think about how to use technology in today's world, which is a driver of a lot of cost savings, and why advisors can now go independent. That all doesn't have to be done in one technology stack through, let's say, a wirehouse or a corporate environment, right? And so really advisors can design what that tech stack looks like, but it's complex, right? Because you have financial planning software, you have portfolio management, you have CRM, then you have documentation. And so if we can design based upon your business, your clients, the assets that you have, what that stack should look like, and how we can use that for compliance and legal up front, it makes a lot more sense to do it on the back end. So prep is key. A question came in actually for Glenn. Glenn, looking back over 5 years ago and knowing what you know now, what would be your number one word of advice to those ready to make the jump?
Oh, I don't know about number one word of advice, but many of you know my business partner, Jonathan Cameron. So we worked on this for a year, I think, about a year, even before we filed with the state for the RIA. Count your costs. Our tech stack, before we came on, I just did some quick numbers. We're spending about $12.50 a month on that. And it could easily be more, But so when you start out, if you're billing your clients quarterly in the arrears, you're, at least 3 months away from getting a paycheck. So, look at your personal finances. Is there another source of income? How you're going to live during that time when you build up your assets under management. The other thing I'd say, any business has 3 legs. You've got operations, you've got marketing, and your production. And Jonathan and I have commented many times, I don't know how single practitioners do this alone. We've had each other to lean on, and I'm much more temperamented to be the operations person. I like my ducks in a row. And Jonathan is much more all software, marketing, that's him. And then together we're the production. Together we work with the clients. I'd say that's a big thing to think through, is because it all has to get done. I mean, you just can't let anything go. You must be in compliance, or you put in compliance, or your living is at risk. You must produce business, or you don't eat. It all has to happen. So I guess that would be the main thing. Really think it through. So we began with very few assets, and have just built it up. And as so many entrepreneurs do, the entrepreneurs we work with as planners, eventually they get to a point where they can breathe a little, take a higher level view of the business, and then put more underpinnings underneath it, to start to farm things out, outsource, so that you can have some kind of balance. But I'd say for 5 years, it's this and nothing else. I mean, you've got to go at it hard for 5 years and never revisit your decision. Fair to say, ladies?
Agreed.
Completely.
Awesome. Yeah. I think that's kind of the nail on the head, is that you're going from, a practice model where a lot of things are taken care of, to launching your own business. And so knowing that you really have to have the business strategy, and as you talked about, the 3 components, you got to want to have a will to do that, or figure out a way to outsource, right? And so a lot of what we help advisors with is we literally do a pro forma and walk through advisors to say in their current environment versus future state, and go through top to bottom, from haircut to trade costs, admin fees, direct costs, all of these things down to see what the cost differential would be and what that would look like with the growth model. So an advisor basically can, or advisory team can make the decision to say, great, it's worth it for me for an X additional percent to do these things myself because it's significant.
Right. And Cammy, just one more thing, got to point out, I'm a business owner now. So every new account, every new $1,000 in AUM increases my personal net worth. So, you know, this is the flip side of it. All the work does pay off. You know, and I never plan to retire. I tell Jonathan someday he's going to come in and find me dead at my desk. But, you know, our plan is to be always have our advisors be owners, and they'll now have tranches of the business I can sell off. So this is also part of it, the succession plan. That's the other end of it. And what are you going to do when it's time to wind it down? That's another topic for another day.
Yeah.
Yes, that's a great point. And in the first session, we talk about the nuances of client ownership and what that means also from an entity ownership. And so that's a huge driver that we know for advisors, particularly if you someday have in mind a succession, is if you're doing all this work, why not, would you not be also capturing value in a business? Well, you can if you don't own your clients, right? And so thinking about that as well, as you're saying, every additional AUM, it's not just revenue today, it's business value for tomorrow. So awesome, thank you. Okay, there's a poll out there that I put, if you all want to keep answering. I'm gonna end it soon, but it's just trying to get a lay of the land where advisors are today. So thinking about the preparation then again to go independent, we've talked about our specialties in compliance operations, legal, and business strategy. And I know that sometimes advisors hear some big name brands out there or out of the box compliance solutions. Do you have any comments on those, Vivian, Tanya?
You want me to go first?
Yeah.
No, you do.
So I see the out-of-the-box solutions, and it's overwhelming for advisors, right? Because you don't know. How do you price? How do you compare value? So that's why I created a list that I'll circulate of some questions that you can ask about what you're getting. So out of the box, you get a template. So then you're going to need help applying that template to your business, customizing the compliance program to your business. You're going to get a bunch of checklists, and then you got to try to figure out half of them may be for an SEC registered advisor. So that's one model where you get this bare bones template. And then also looking at your Form ADV materials. Yes, nobody reads them. Yes, it's a required finding, but it's the first document you give to your client. So it should be part of your branding. It should have your logo. It should have, it should integrate, and it should really match. This is what my business and my business practices. So you don't get that with the template. The other model is a little bit overwhelming as well because it's more about a la carte. So you get basics, and then you buy this service, and then you buy the checklist, and you buy a different program. So that also becomes where you might end up overpaying because you're buying this package and maybe you can only use 3 of the checklists. So the model that I like is I tailor it to the advisor. I give them a fixed fee, and that includes everything but customize. A lot of times I'm brought in to do the customization after the advisor has been in business and has had an audit, and now they're being criticized because they have a template. So it ends up costing more in the long run to pay for the template and then pay for customization. So I prefer having one price where the advisor knows this is my budget, this is what I'm, and I feel comfortable that that I'm able to customize. Now, there are a lot of questions that you need to ask when you're interviewing your potential compliance advisor. How do they customize the products that they're going to give you? How much work is involved in your part? So a lot of times they have you complete a questionnaire. Well, if you don't answer it correctly, your program and your responses and your disclosures are going to be driven by the wrong answer, that maybe you didn't understand what the question was. So, and that brings a lot of work on your end. So maybe you're better off, let someone ask you the questions, tell you this is what you need, confirm it with you, and then you don't have to waste time with questionnaires and going back and forth. So that's my experience.
So this is great, and the answers to the poll came in. So we almost have no wirehouse or regional banks coming in. about 20 of us are with independent broker-dealers currently, and about half of us are with RAs or hybrid IRAs, and the other 25% of us or so are not affiliated. And so now, kind of knowing as well our audience, I got a question from Steve Taylor, the president of the FPA Miami, who has set us off on this practice management series and hosted our very first series. So hi, Steve, and thank you. He has a question for you, Vivian, about being on the other side. So some of us may know that Steve also launched his own RA this past year, and he feels like he's getting bombarded by compliance websites, and he doesn't know how to distinguish them. So on the other side, what's the best way to simplify and streamline your compliance life?
Right. So you need to, again, it goes back to what do you really need for your business? If you are, if you're dealing with international clients, you need to have an AML program. You need to have, and the custodians and the product sponsors will not deal with you if you don't have that type of a program. But if you don't have that kind of business, if you're not offering wrap accounts, if you're not offering, if you're not in, you don't have pension consulting clients, you don't need 20 pages of procedures and checklists that don't apply. So it's really going through what are the bare bones basics that you need, but then making sure that you follow those and apply them, and then implementing a program that works, that really protects you. Understanding the reason you're all doing this is for liability reasons, right? You have a regulatory issue or you have litigation. So when you go to Tanya, you want to be able to have documents that says, I manage, I implemented, I reasonably supervise, and it's in one checklist. You're not spending half a day documenting things. So that's so it's about doing smart compliance and not just having a lot of checklists and sign here. I actually saw a client that had a 600-page procedures manual. Okay, most of it didn't apply, and then it had all these processes. You have a committee, and then you sign, and you write a memo, and you initial, and like impossible to comply. And the only good thing with that kind of manual is the regulators will only look at the index, right? So they're not going to criticize it until you have a problem. Then they're going to read the entire chapter, and they're going to confirm that you're not doing any of it because you don't even know what's there. So so to me, Steve, it's going back to, customization and really understanding what do you need and what do you really need to do, and spending your time wisely on doing what's required, but not wasting time on things that are just not necessary.
Excellent. And Tanya, in your experience working with various consultants, or how do you work with bridging the legal and compliance side on both setting up and then, afterwards on the back side? Uh-oh, is she frozen?
Yeah.
She was about to say something profound. Uh-oh.
I can speak to the other side of that, okay, which is I try to be very proactive because I was a regulator, because I've worked with enforcement attorneys. What I see with other consultants that can be problematic is they don't see where to draw the line, and they continue and they're trying to help the client, but they really don't help the client. So if we're doing an audit and I see by the questions, by the issues, that we're getting to a situation where, potentially this could be an enforcement situation and attorneys need to get involved. I'm going to be a bit proactive to say, you need to get an attorney. Okay, you need to get an attorney involved. Whereas other consultants, they really mean well, but they can end up hurting the client by responding to letters, to deficiency letters, in ways that can ultimately not work in the firm's favor. Okay, and the same thing happens with documents. You're launching, a lot of people say, give me a template. It's my client agreement. I don't want to spend money on a client agreement. It's the most important document for your firm. So it's foolish to not have an attorney look at it. And so some compliance consultants will say, well, I'll give you a template and it's a value added service, but I'll say, you know what, I don't think giving you a service is that's a disservice if I give you a template. So that's an example. And I also encourage
make a point to add on to what Vivian just said. you're going to hire compliance, but at the end of the day, it's your firm, it's you and your firm is responsible. So even if you're outsourcing compliance work, you still need to know what it is, and you still need to know what you're responsible for, and you still need to be able to answer for it all. So they're your partners. Nobody should ever have the picture that I'm outsourcing this work and I don't need to think about it anymore. They're your consultants, and maybe they'll pick up bits and pieces of it, but it's still your work and you still answer to a regulator for it. And the regulator is looking for how well are you supervising your business for the benefit of the public, for public safety. That can't get delegated.
I think that's great. I think that also a point that kind of bringing it all together with things that Vivian and Tanya have said as well is, again, what they really focus on is streamlining to that advisor's business, to their practice, to their clients, and setting it up right up front. Yeah. So that by the time the exam comes around the next time, or by the time you've moved clients out, assets over, and it's been 3 or 6 months, you're using technology, you have your calendars already giving you the flag. So they really help you get set up to what Glenn's saying is take responsibility to do it, but that it doesn't run your whole life, right? And I think that that's something that we've noticed with maybe some of the out-of-box solutions is because it's not tailored and streamlined, there's unnecessary complexity, but then deficiency in the areas that are crucial. So this is exactly what we're trying to help you avoid. Okay, Tanya's back. Welcome back, Tanya.
My biggest nightmare, of course, the Wi-Fi went out.
Oh no, that's okay. So one of the questions that also came in was about custodians and wondering, is particularly in South Florida, which of the large custodians are most friendly to international clients? And I think Vivian's done a great job talking about designing compliance programs. If you do have international clients, you're going to have the AML program. You're going to have to, back to all these different laws. Vivian, do you have any comments on custodians? We like them all for various reasons.
Right. So it really makes a difference, and that's the analysis is what is your book and what are the products and what are the countries. So if you have a lot of layered relationships, so you have a trust that's owned by a personal holding company and there's 2 or 3 layers, or what is the concentration? Right now, the highest risk is Venezuela. So if your business is Venezuela, it's going to be really tough to find you a custodian. So they only, but then we try to find other solutions for that might work. So it depends what countries are you in. Certain custodians will accept accounts from these countries and not others. And then also what products. So sometimes, we can get you with the country and we can get you with the type of accounts. What you don't want to do, and they want, is find out your biggest client has products that don't transfer over. Okay, and I've seen that happen. So we do the matching of the products to what the custodian has and make sure that there's selling agreements in place before we try to make the transfer. So a lot of it goes back to the planning, and it's specialized to your business. And if you're international, it's going to be more complicated.
I think also in terms of international clients, I think that Schwab does a good job, but again, it's going to be about the layers and the complexity, as Vivian said. There's also some boutique custodians out there that, if you think about it this way as well, that may be different. You may be multi-custodian. So as an RIA, you have the choice where you actually want to custody your money. With an independent broker-dealer or a wirehouse, they do some things very well, but oftentimes they limit you to one custodian because they're trying to get the economies of scale. So potentially you might also segment your business to have a boutique custodian for that portion, and then maybe for the larger portion, larger assets there. And you use technology to aggregate and integrate all of those things for reporting and for your own reporting. So, okay, now that Tanya's back, Tanya, especially on the legal side, and you oftentimes get things on the back end when mistakes have been made, when things haven't gone so great. And we while you were off, we talked a lot about streamlining to the practice itself and not going overboard, but then being deficient in the key areas. So if an advisor kind of just goes and sets up their plan and their RIA, and they don't really get down to the T of hiring a great consultant to make a program specific to that business, and there's deficiencies in some areas. What are some of the horror stories that you've seen, and how can they be avoided?
Yeah, so unfortunately it happens a lot, and that's kind of an area we do a lot of business in. A lot of times advisors, great people, great advisors to their clients, the last thing they really want to deal with is compliance. So they turn a blind eye to issues, or they set it up maybe, pretty great, but 10 years down the road, they haven't done anything since the day they set it up. Or sometimes they set up with a consultant that wasn't the right consultant for them. And so they did get a lot of these like untailored materials to their business. They never really got an exam, especially at the state level now. The state isn't coming in to examine some of these RIAs until like 3 years in, 4 years, 5 years in. And so you've been doing business for 5 years with materials that are not adequate to the regulators. So the first issue that we have, and probably the most detrimental, is advisors trying to deal with the regulators on their own. So the regulators come in for exam, they either get their consultant involved who was probably not the best consultant for them in the beginning. So that's its own problem, because maybe the consultant doesn't even see the deficiencies. And then they deal with the regulator on this exam. Sometimes the exam can go upwards of a year, because the regulator's just kind of checking every time you say something that maybe you shouldn't have said, or it's very clear that you don't know what you're doing on the compliance side. Regulators just taking note of it, gathering deficiencies 2-3 years into an exam, which has now turned into an investigation. You thought you answered all the regulators' questions candidly and you did everything right, and you get a crazy fine, or regulator wants to shut down your business. It happens all the time. And so what happens is these RIAs then come to us saying, oh my God, look at this fine I just got. Is there anything you can do? And by that point, we're just begging for forgiveness. So if you do find yourself in that situation, if you do get your first exam, the first thing you want to do is make sure that you have someone involved that you're comfortable working with. So whether if it's your compliance person, a good compliance person knows when to stop their conversations with the regulator and refer it to a legal counsel to deal with it some other way. And then if it does progress into an investigation, sometimes you don't even know it's gotten there. 100%, that's when you should cut off communications and get counsel involved. So what some horror stories that I haven't seen anyone barred from the industry. So I can start there. The way you get barred from the industry is if you just don't care whatsoever about compliance and it's very clear, or you cause harm to your clients. So that's how you get barred. But we've seen some really lofty fines that, $5,000 for this, $5,000 for that. Next thing you know, you have a $100,000 fine and you only have 30 clients. So the fines alone can put an advisor out of business completely. So you want to make sure that you set up your RIA correctly from the beginning, and you hire, or if you're good at this stuff, I haven't met a lot of advisors that are, but if you're good at keeping up with everything, that you are doing those things in your business. You want to make sure that you're keeping up with the regulations, that if someone comes knocking tomorrow, you feel confident that your business is in good standing, because you don't want to get to the point where you're in that investigation stage. So some horror stories, the horror stories really are just financial aspects of it. I fortunately haven't seen any advisors with so many deficiencies that it's causing harm to their clients. Usually it's a matter of paperwork or not tailoring the materials to your business. That's like probably the number one thing we see. Collecting, compliance manuals you find online and putting your name on the top of it is just not going to fly. And regulators know that. They know what you're doing. So another thing is getting those materials, having them quote unquote applied to your business, and then not doing what those materials say you're going to do. So compliance manuals, especially if you, like Vivian said, there's 5 steps you're supposed to take and you take 2 of the 5, whether or not those steps are reasonable, whether or not it made sense. If your materials say you're supposed to do it, do it. And so those are like some of the the horror stories that we've seen, a lot of times what we do is as soon as we see that there's a number of deficiencies that the regulators are seeing, we go and we refer them to a different compliance consultant and make sure they're paying for everything again to have a compliance consultant really put their business compliant again. And so if they had paid for those services up front and, you know, taken an interest of it originally, they would be in much better shape when the exam came along, and then not maybe double paying for those compliance services.
Awesome. Thank you, Tanya. That's excellent. I believe also that, you know, part of having the coordinated business compliance strategy is that we help advisors create calendars. So a lot of us are used to, at our independent broker dealers or wirehouses, you know, doing our business planning, goal setting, let's say at the beginning of the year on whatever those, you know, production targets are. And so what we'll do is help form a calendar to say, well, at the beginning of the year, maybe it's, you know, business strategy, and quarterly it's X, and then compliance, you know, is a small piece of that. So it just becomes part of that process that an advisor gets used to. I think the other thing is a lot of us do already have hybrids or our own IRAs on this this session. So I think the other thing is that we just urge you to build that into the process, that you recheck, right? You hire a consultant to get your materials reviewed, because also we find that a lot of times it's just an advisor doesn't know, especially because there's so many moving parts at the beginning. So it might say that you have a wrap account and you actually don't, or, you know, or you're starting to charge financial planning consulting because that's the business model you want to take, but you didn't update the ADV. So that's a good thing just to build into the process. It doesn't have to be January of each year. Maybe it's July when it's quieter, but to build that into the process and to periodically have those materials reviewed in advance of the audit. So Steve actually asked a great question as well, which is, so comparing an experience if you're affiliated with an independent broker dealer now, compared to if you're an SEC an RIA registered with the SEC or the state, what's the difference in the audit experience? And he's specifically asking that to Vivian, Glenn, and Tanya.
Tanya, you want to go first?
Yeah, so I would say there's a big difference. If you're affiliated with someone, usually they have people who can help you through that exam process. Some people in the back office, they want to make sure that you're staying compliant, plus you're using a lot of materials that they might have provided you. It makes the process a little easier. I think the biggest difference would be if you're an RIA, if you're state registered versus SEC registered. We find that going through a state register or a state audit is a little bit more difficult and time consuming than an SEC audit. SEC tends to move quicker. They tend to find the deficiencies, be a little bit more reasonable about them, and move forward. The state, they see a lot of turnaround in their exam people. And then once you have a new examiner on your case, sometimes these examiners are working on your case for 6 months, and then someone new comes in, they start all over. And so we've seen people in the exam process for 3 years at the state level. And sometimes those turn into investigations. If it turns into an investigation, you might be there for 5. So if you can get state registered or SEC registered, the exam process is a lot smoother. It's a lot quicker. It's really honing in on certain aspects of your business and moving on. The state, at least state of Florida, they're more focused on trying to look at everything and trying to find every little issue, and it takes them longer. And because they do have a lot of turnaround in their examiners, the process can go on forever, and it eventually gets very costly.
Yeah, and I just had an experience with a client. He got the audit letter in December, and they asked him for 3 years of business records for every business record. And he's had 2 follow-up letters since that, and that's with the state. So with the SEC, it's much more reasonable. It's more risk-based. They're more likely to find things, significant things, right? Because they're really focused and it's risk-based, but it goes much, much quicker. With the state, it can be really unpredictable, and there's, you know, it becomes really frustrating because it's such a broad request and you still have to comply. And then the questions keep coming. And then like Tanya said, there's times that they start over or they lose the documents. So we could almost do a different session just on managing exams.
Yeah, we have a lot of clients that as soon as they get an exam, they just turn over the communication to us. I hate to say it, but dealing with an attorney tends to just make things go a little quicker. Of course, you're going to pay for it, but it is, especially at the state level, you can get pulled into that for so many years, and the cost would exceed, even if you're compliant, honestly, the cost would exceed any payment to an attorney to deal with them and try to knock it out quickly.
That's awesome. So it seems like also when those things come up, to be prepared, you could have a consultation or hire a compliance consultant like Vivian, or hire Tanya, a legal firm, to at least have your ducks in a row and representation to know how you should approach the exam, to have them on board. And if they walk in that day, you've got the call ready to go, right, for them. And based upon the size and complexity of the business as well, right? Tanya deals with a large range, of billion-dollar plus firms all the way down. So there is a different complexity. But one point of clarification, Vivian, can you help us with this? Why would an advisor register with the state versus the SEC?
So it's the requirement is based on assets. In Florida, you need 100 million in assets under management and to be with the SEC. So it's really an asset test.
Perfect. So it's a state-based requirement based upon AUM. And in Florida, it's 100 million to be registered with the SEC. Right. Less than 100 million, it's with the state of Florida. Perfect. Thanks. I know that a lot of times advisors ask, well, what's the difference? Do I have to do both? How is this, especially if they're coming from a dual registration world where they're on a corporate RAA of an independent broker-dealer wirehouse, and they've got a FINRA registration. They're just used to seeing, it's come through, you're registered. So to really, understand the different regulatory bodies is helpful. Glenn, what about you from your experience? You've had an audit.
We did. It was November, December 2018. And I'll tell you, and Steve, particularly, the best thing we did was that we have on our ADV that our office hours are by appointment. So I've learned that when you have that, they never just show up at your door because they call and make an appointment. So we knew regulators were coming. We walked them through it was 2 people, and the one that we ended up working with had been with the state for about a year. And we walked them through our whole compliance program, showed them the compliance flow. I actually got a compliment on my record keeping because we had always done everything electronically. But what it was, they gave us a list of 31 accounts. And there were about, I want to say, something like 50 points to address on each one of those accounts. And the points, sound right, Vivian, about 50? So so for this account, all your email correspondence for the last year, all of your notes for the last year, all of the account statements for the last year, all your fee billing statements. So, we had all of it was the job. I figured it took about a week. And then getting it to them. My examiner couldn't figure out how to use Dropbox, so that didn't work. So I ended up, for each question, sending all the answers. And then the frustrating thing was I was teaching him halfway through about compliance. But, question 5, I didn't. So down the line, question 19 essentially repeats question 5. And he's asking me question 19 like it's brand new. Well, come on, pal, go read question 5. No, it doesn't work that way. I'm on the box for question 19. So this is how it's done. And, all you can do is work with it. You certainly don't want to antagonize these people. I mean, they've got a job to do too. You got to respect that. But it was, for us, it was just largely collating stuff. And we got dinged on a couple of really minor things. One of them you'll all appreciate was we've got a fee schedule like anybody else, breakpoints. And we were actually charging a client less than what our fee schedule said. Less, not more, less.
We see that all the time as a deficiency.
I was just amazed. I thought, are you kidding me? Yeah. So
And I
that
think
some of my IPSs were 4 years old. So, you know, that was something I was totally unaware of. So we keep our IPSs fresher and I don't know, whatever else it was.
yeah,
But that was it.
the way Glenn is describing that exam, it went a little smoother for him, it seems like, but that is how tedious they all are, especially at the state level. And they'll repeat themselves, they'll lose your documents, you uploaded things and they said you didn't, and it does get, and again, it depends on the examiner, of course. You had someone who was a year out still learning. But we do have that experience, and a lot of times advisors will just turn it over the communications to us, and us saying to them, unfortunately, a lawyer saying to them, your 18 is the same as number 4, sometimes puts the issue to bed, sometimes.
Wonderful. Well, thank you so much, everybody. There was one thing Steve said, thank you for letting me know that office hours by appointment on the ADV can be helpful for exam preparation. So thanks for everybody for joining today. Thank you also, Glenn, for hosting us from the FPA of Miami, and Tanya for joining us, Vivian for joining us. All of our contact information is available will be sent to you and will be available on the website. I also put it here. If you want to take down our email addresses for each of us, Tanya, Vivian, and Cammy. And hopefully everybody has learned something today. We'll be doing another session a few weeks down the road. We were about a month from last time, so about in the next month, we'll come up with a good topic. We ended up having some more participants join, so it seems like there's some interest in the topic, which is wonderful. If you have any additional questions, we're happy to just be a resource to brainstorm or answer anything. And hopefully we didn't scare you away too much. So hopefully you know that you've got experts who clearly study this all day long, and advisors who have been through it like Glenn for 5 years and, you know, are building business value, taking care of clients, and enjoying his business. So thank you again. Have a great rest of your day, and we will see you soon.
Bye.
Go on, everybody.
Take care.
Bye.